Muito bom dia a todas e
Good morning,
todas. Todos, eu sou
everyone.
Fernando
My
Hoffman,
name
juiz do
is
trabalho
Fernando
do TRT
Hoffman. I
da
am
nona
a
região.
labor
Estou
judge
aqui junto
at
com o
the
desembargador
9th
Eliásia
Regional Labor Court.
Medeiros,
I'm
com
here with Yasa
Lourival
Medeiros,
Barão e
Lorival
Marcos
Barão, and
Blanco.
Marcos Blanco.
Somos os juízes
We are
supervisores
supervisor
da quarta
judges
edição do módulo
of the
prático do
fourth
curso
edition of the
de
practical
mediação.
module on
Estamos aqui
mediation.
abrindo essa
So we are here
palestra que
opening this
encerra o quarto
talk, which
módulo
will wrap up the
do
fourth
programa
module of
prático
the
de
practical
mediação, abrindo
hands-on
para
program
as
on
24
mediation,
escolas
opening this to the
dos tribunais
24
regionais de trabalho
schools
brasileiros, também
of the
para o
Brazilian
Ministério
Regional Labor
Público do
Courts, and also
Trabalho
for the
e para a
labor
Escola de Formação dos
public ministry and
Servidores
the
do
School
Tribunal
of
Superior
Training
do Trabalho. Sejam
for the
todas e
Regional
todos
Labor
muito
Court
bem-vindos
employees.
para
Welcome you
essa
all
palestra
for
de
this talk,
encerramento. Nosso
this
curso
closing
já
talk
formou
of our module,
centenas
of our
de
course, which has
mediadores
already
e é com
trained
muita
hundreds of
honra e com
mediators,
muita
and it's an
felicidade que eu
honor
recebo
and a
aqui
joy to
a
welcome
minha, não
here
vou dizer
my,
ex-professora,
I'm
mas
not going
a,
to
a
call her
minha
my former
professora de
professor,
sempre,
but my
Stephanie
always
Blondell. Seja
professor,
muito
Mrs.
bem-vinda, professora
Stephanie Blondell.
Stephanie.
Welcomes
Professora, ela
Professor
é
Blondell.
associada
Professor
de
Blondell is an
Direito e diretora
associate
acadêmica no Instituto
professor of
Straus para
law
Resolução
and
de
faculty
Disputas,
director
onde
at the
lidera
Straus
a
Institute
Clínica de
for Dispute
Mediação do Straus e ensina
Resolution, where
vários
she leads
cursos,
the
incluindo
Straus
teoria
Mediation
e
Clinic,
prática da mediação,
teaches
psicologia do
various courses
conflito
including
e
mediation theory
advocacia
and practice,
ética. A
psychology
professora Blondell
of
desempenha um papel
conflict and ethical
importante também
lawyering.
na
She
Academia de
plays an
Negociação para
important role in
Mulheres
the
e
Humans
ministra o curso
Negotiation Academy and
Mediando o
teaches the
Caso Litigado
course
em Várias
mediating the
Localidades,
litigated
um programa
case in
de
several
uma semana
locations.
que eu
This is a
fortemente
one-week
recomendo
program that I
a
strongly
todos vocês.
recommend to all of
Antes de
you.
se juntar à Pepperdine,
So
ela
before
gerenciou o
joining
programa de
Pepperdine, she
resolução
managed the King
alternativa de
County
disputas do
Alternative
Condado de
Dispute
King, em Seattle,
Resolution
e foi a
Program in
coordenadora
Seattle.
de resolução
And she was
alternativa de
the
disputas para a
Alternative
cidade
Dispute
de
Resolution
Seattle, onde
Coordinator
também
for
implementou
Seattle
um
City
programa de
Government,
mediação
where she also
na
implemented
área
an
trabalhista.
employment mediation
Recentemente, ela
program.
recebeu
She
o
recently
prêmio da
received the
Associação de
Southern
Mediação do
California
Sul da Califórnia,
Mediation Association
Associação de
President's
Mediadores, em
Award
2021, e
in
agora, mais recentemente
2021.
ainda,
And
2023,
in
recebeu outro prêmio da
2023,
mesma associação,
she received
o
another
prêmio
award from the
L.
same
Randolph
association,
Laurie.
the L. Randolph
Agora, me
Laurie
permitam
Award.
aqui a
Now allow me
liberdade de falar um pouquinho em inglês
to
para
speak
saudar a nossa querida
English
professora.
to her a
Well,
little
first
bit.
of all, I want to share with my colleagues that very recently, Professor Stephanie lost her beloved father. And here I wanted to express my condolences for the painful loss and wish that you and your family find the strength to deal with your father's passing. We are all moved by your presence today, and your effort to be here is something that inspires us mediators to move forward in the face of adversity. That being said, my initial invitation to Professor Stephanie was made at the request of the Public Ministry of Labor, Ministério Público do Trabalho. They approached me for a recommendation of an excellent professor and a huge talk. And they were very pleased when they learned of your name. Unfortunately, participation there was not possible, but I decided to take a risk and invite you to today's event. And I am grateful that you accept. Stephanie was my professor in the mediation clinic during my master's degree in the US. And there she was responsible for teaching mediation in practice. My colleagues and I would go to the judicial courts to observe, co-mediate, and mediate. And from there, we brought back good experience, best practice, and let's say not so good moments sometimes. We would debrief, discuss cases, and receive feedback, something very valuable for mediators. And Professor Stephanie, that is basically what we do in the 60-hour practical program that ends today with your lecture. Nobody better than you to be here today and to talk about the learnings we have in this very important stage of mediation. We are looking forward to your approach. You are very welcome, and the stage is all yours.
Thank you so much. Thank you so much. Thank you. I appreciate Professor Hoffman, Judge Hoffman, for having me here, and all the other esteemed professors, judges, prosecutors that are joining us today. I appreciate the invitation to speak with you this morning and talk a little bit about the practical skills of mediation, of which you've just, I'm hearing and learning, completed your 4th module. As you've already heard my bio and my background, I have a special appreciation for labor courts, as well as the entire judicial system. I have spent my career in court-annexed mediation or labor mediation. Those have been the 2 primary places that I have run panels of mediators. So I worked originally, my first jobs in mediation were in court-annexed mediation, where we would show up on the day of hearing and try and mediate cases. Then I moved into the world of labor and employment, and I have returned to the world of court-annexed mediation as I run a clinic at Pepperdine Law School. This clinic trains mediators from around the world, as well as domestic U.S. lawyers in the skills of mediation. My personal raison d'etre, reason to be, is to help people take the theory of mediation and put it into practice, what we call table skills, to focus on the table skills of mediation. And that's what I am here to talk about. I've organized this particular talk, as you can see, around lessons from the world of clinical education. So those things that people routinely and archetypally do incorrectly as they're transitioning from the world of advocate into mediator. So we see patterns. This is my experience. I've trained now over 1,000 mediators in the practical skills, and how they take the skills and translate them into the practice of mediation can be quite typical, I think, in the initial problems that arise. So I'm going to reflect on this particular aspect of teaching mediators. Over the years, I've run what we call practicums, where you take mediators and put them through skills-based boot camps. And then in Washington State, where I was from, we ran a practicum where people needed to co-mediate 6 observe first 6 mediations, then co-mediate 6 mediations, then move into 6 real solo mediations. All of those actually were cases, grievances, unfair labor practices. They were court annex cases or lawsuits. And so that practical skills training that underlied the experience of learning to be a mediator is critical. So the first thing I want to start with is looking at what are those skills that make good mediators. I'm not going to spend a lot of time on this particular slide because, as you can see, it's words, 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 words. And as we're dealing with interpretation, that may be frustrating. I'm going to focus on a couple of these competencies. But as we're taking mediators from beginners to proficient, these are some of the things that we look for to make sure that those mediators have competencies. Part of what we look for is, do the mediators understand more than the rote linear model? Because the mediation model, as you've learned, is so much more than being able to bring people through the stages in a mediation, but being able to adapt and take certain stages, using them out of order if that's what the particular parties need, or to return to different stages because of the circular nature of conflict and people's conflict narratives. So this nonlinear approach is just as important as the beginner's linear approach, the ability to flex into that. We're also assessing whether or not people can use those skill sets that you've been taught, active listening, if you're choosing the right tool and using it for the right time, if you're able to build rapport with each of the parties, if you're able to understand and effectively use what we call the BATNA and WATNA, so I'll spell that out, B-A-T-N-A or W-A-T-N-A, if you're able to talk about the next stage, which of course in court annex mediation is always the lawsuit, the grievance, if you're able to talk about that next stage in a way that without overusing your power helps people understand the risk that they're facing. We look to make sure that the mediators know how to use impasse breaking techniques. And we look to make sure that people are able to close. Because you can mediate all day, and unfortunately I've watched mediations that go on all day, but at a certain point there needs to be those closing techniques. These are the mediator competencies that we look for. Now I'm going to pause and go on to what I've chosen, which are 7 archetypal new mediator mistakes. Those mistakes are as follows. New mediators tend to underutilize the skill of interest identification. Interest identification, I'm sure you've been taught, and I don't want to repeat what you've been taught, but I'm going to go back around and circle on that skill for a moment and highlight, basically take my yellow pen and underscore the important aspects in an attempt to get usually lawyers who I'm teaching and judges to use a skill that is not part of the language of legal discourse. New mediators tend to misunderstand the persona of mediators and tend to underutilize their skills because they may misunderstand the breadth of that particular skill. New mediators tend to do something we call reality testing too soon, which means they tend to ask those questions of risk and cost in a way that does not fully utilize the skill to its, I'll call it its best ability. Reality testing is one of the most effective and impactful skills that a mediator has, but used too early or used too frequently, it's not as effective. Most new mediators struggle with using reality testing and maintaining rapport at the same time. That is a difficult skill. That's a difficult skill. I still am challenged by this skill, and we'll talk a little bit about it. New mediators tend to ask questions that are too long and sometimes confuse the parties. So there is a value in pacing your questions or in asking longer questions as juxtaposed by short, crisp questions. My final 2, new mediators tend to misunderstand the value of empathy or misunderstand the actual definition of empathy and therefore the practical skill set as applied. And finally, new mediators underestimate their value as a person not involved in the conflict. And we will talk a little bit about that at the end. It sounds like a funny statement, but there is quite a bit of wisdom in being able to harness the value of not being involved. So that's our agenda, and I'm going to quickly cover these 7 points this morning, then leave some time for question and answer for you. First, new mediators underuse interest identification. So we'll talk about the skill of interest identification and then talk for a second about reframing. And you've been taught the skill of interest, I'm quite sure, but I'm going to, like I said, highlight it, use my yellow pen to highlight it, because what I do not think most mediators do, despite having been taught the skill as a problem-solving skill, is change the vocabulary words they use into a vocabulary of interests. Interest identification is the vocabulary of conflict resolution. So rather than thinking about interest as something I use in a sentence to define or ask a question or recap, think about the entire narrative that you are speaking in as interest-based. And part of the theory there is if we use interests, then the parties will start to use interests. I'm going to come back to that in a moment. First, I want to cover what are interests, and I'm sure you're aware this is the definition of interest I use. They are one-word statements of needs and values. And interests are always positive. Why one word? One-word statements of needs and values because we're more likely to help the parties get out of their conflict narrative, that loop where they're going around and round. We often call it Maytagging in the United States. I don't know, that's the name of a particular washing machine brand. But when you look at an old washing machine where there was, you know, you can see the clothes going around and around, that perseveration or that loop where the parties get lost in their conflict narrative, we are more likely to be able to stop that perseveration if we are able to identify that value in a powerful and impactful one word. What happens is that when most people use phrases or longer sentences to identify interests, it doesn't have the same sort of value of translating the conflict narrative from, what should I say? Translate the conflict narrative from being stuck into the language you need in order to negotiate. So for example, I'm going to take a very simple example of a workplace where someone is talking about a boss who is a micromanager. So employee says, they're down my neck. They're looking over my shoulder all the time. I can't get anything done. I can't, they think I can't even add 2 + 2. Now listen to the two different interventions. The first intervention is going to be an identification of interests that's long. And the second one is going to be a one-word statement of need and value. So here's the first. So it sounds like you need to be able to be trusted in the workplace, and you need to be able to have some space and to be respected as an intelligent member of this workplace. Okay, that was one. Now that is good, right? That was very good. And it might really be an important and meaningful intervention at some point in the conflict resolution. But it does something different than this next one. So let me give you the second one. autonomy is important to you. Can you now give me an example of what autonomy looks like? Okay, so you see that second one was the transition statement into actual negotiations or problem solving, or in a lawsuit, the terms of an agreement. So when we think about interest identification, think about it as more than a narrative paragraph, but narrowing it down to that one-word statement of needs and values, where you then can ask questions to allow the parties to identify the terms that would meet that interest. So in this way, interest identification is the transition skill between fighting and negotiating. And the mediator's job is to be that bridge. But that one-word statement is critical. The other important aspect of interest identification is that interests are always positive. And this is something that I see new mediators doing quite a bit. They sneak back down into the concept of interests being values that they hear, but not necessarily positive values. So for example, if you're working with a party and the party says, this is a plaintiff, and the plaintiff's saying, in a caucus form of mediation, I want them to pay for everything they've done to me. They have made my life horrible, and I want them to pay. The first word that comes to my mind is revenge, right? And what we ask new mediators to do is to think of revenge, because that is a need and value that we're hearing if you're like me, you're hearing that very strongly, and you've heard this before, most certainly. But revenge is not a positive word. So instead, we label the word revenge as a strategy. Revenge is a strategy to meet a deeper underlying interest. Revenge is a strategy to meet a deeper underlying interest. And what might that be? And with the narrative I just gave you, you may not know. You may not quite know what the deeper underlying interest is, but it might be something like closure, accountability, justice. And that's where we as mediators then take that concept. So let's say it's justice. Justice is important to you here. And then I might be a little bit more reflective. I might say something, if I'm being a more evaluative mediator, I might say something like, justice is something that I see so many of the parties who come before me in the mediation room trying to achieve. And it's always interesting when justice is juxtaposed with a money value, a dollar amount. Because few people feel a sense of justice with any dollar amount. So let's talk more about how this dollar amount might be a symbol of justice. It's a symbol of justice because you've gone to the top of the insurance cap. It's a symbol of justice because it's a symbol of justice. And you help the parties think through that. So in that way, you transition someone from revenge to some other deeper underlying interest. Our interest words are these words, which you've been exposed to. This is just by way of a little bit of review, but they're words like stability, reputation, acknowledgement, appreciation, fairness. And as you know, fairness is very different than justice, which could be very different than equity, which could be very different than dignity. And those are words that often come up in labor disputes. So this question, and I'm sure you've heard the orange story, what about the orange is important to you? I only put this up here because there's this, kind of quintessential story in conflict resolution about the orange and seeing that there is more than what underlies the peel of the orange, but there are the segments, and that's where the interests are and the potential for integrative solutions. And I just put this up here as a little joke. I think that question to get at interest, which is what about the orange is important to you, or what about the blank, fill in the blank is important to you, is so important that I actually have thought about getting it tattooed onto the inside of my wrist. As you can see, I've thought better of it. I have not done that. And it looks terrible, so I'm not going to do that. But I have thought that this next question, what about the orange is important to you, is that important of a question for a mediator. It is the question that comes back over and over again. Okay, so that's our first concept, which is what the interest words. I'm going to give one quick example, because now that you have the interests, what do you do with them? I'll give one quick example and then we will move on. Here's a scenario. And for the interpreters, I will read slowly here. A dispute between labor and management has emerged based on interpretation of the collective bargaining agreement. Labor reports that regular labor management committee meetings, which are called for in the agreement, are lacking. They have not happened. Labor also reports they did not receive safety protocol and policy from management as required by federal regulation. Management reports labor has regular scheduling conflicts, making meetings impractical, if not impossible. Management accuses labor of trying to set up litigation unnecessarily. So I've taken a very simple dispute, one that would likely not rise to the level of a grievance in the US. I have no idea. In your beautiful country. But I did want to use this example to illustrate the layer of interests, because there are often interests underneath the interests. So on the face here of this particular little scenario, we see that labor has interests, the ones that they articulate. Labor would articulate in this particular conflict that they are interested in protocol, procedures, safety. But what are underneath those interests? Because those are all one-word statements of needs and values. But sometimes we use interests as a tool when underneath this layer of interest, it might be something like respect. It might be something like valuing the relationship. Likewise, management can often have the same interests as labor. Management's interest in safety may be equal to, if not greater than, the labor interest in safety. And from their perspective, protocol and policy, maybe different protocols and different policies, are equally as important. But management also has an interest here not to be treated disrespectfully. So respect is their interest, as they don't want to be gamed. They don't want anything gaming to set them up for litigation, right? So there are different layers of interest, and that's something else that the mediator is regularly looking for that sometimes can be missed. Of course, the skill that you've learned, no doubt, in order to address this is you remove the bad guy from the sentence, and you try and identify that interest. So we call this reframing. And reframing is simply saying protocol is important to you. Respect. And I often don't even need to finish the sentence. Sometimes it's just a word, respect. And that is often the thing that will break an impasse or bring us to fruition. I recently was training a new group of mediators, and they were all JDs. They were all our Juris Doctors, all of our new young lawyers. And they have completed, many of them, 32 units in dispute resolution. Then we send them out to the court in their final kind of capstone class. And the reflection I got from one of them is, oh, I heard all of these role plays where, you know, really respect was the issue, and I didn't believe it. And recently, after having gone out to the court and completing her 18 cases, she says, what I learned was that actually it often was respect. That those role plays that no doubt you all have similarly been put through a series of was reflected back in terms of the litigants in the court annex mediation system. So, okay, I'm going to bring us to our next lesson. That first one was the longest. The next are crisp. New mediators tend to misunderstand the persona of mediator. And I want to introduce you, or it may not be an introduction, it may be a review of a concept called multi-partiality or omnipartiality, or articulating your role as a mediator. So in the orthodoxy of mediation across the world, really, we think of the mediator as the neutral, the same way that you would think of as a bench officer often as the neutral, the judge, the hearings examiner, that type of thing. However, there is an active stance that the mediator often takes that is something different than neutral. If you look up synonyms in English language for neutral, they're words like disinterested. They convey a lack of connectivity to the parties. And that's wise in court annex in the courts often, because the bench officer or the finder of fact does have an arm's distance for valid reason. The mediator has adopted this role often of the neutral as disinterested. In the US, at least, I think this is because we do not teach neutral language. We don't teach people how to ask open-ended questions. In our country, having an opinion is everything, and being able to articulate that opinion. And it's an individualistic culture in many ways, and so the individual has a thought. And many new mediators stepping into the role don't even know how to clean up their language in a way that sounds like they're not for the other side. So new mediators in our country over-determine the concept of neutral. So they tend to be disconnected. It takes a while, I believe, in order to practice the language of not being connected, to then step into a different persona of the mediator, and the persona of the mediator that is the most effective. When we do studies of the mediation advocates, and that means the people who are showing up at mediation as advocates, the lawyers, what they say is they want a mediator who's working for them. This is tricky. Someone's working for you at the same time, they're neutral, right? So there's an analogy, and I don't know if you've seen the Thomas Kilmann scale before. I'm going to assume you may have, but we have conflict styles where you can see on these two axes that this axis, which is asserting your own interests versus asserting the interests of others, are the positions of competing. I assert only my own interests, and asserting the interests of others, I assert only the interests of others, which is accommodation. The mediator takes on what I call the collaborative persona and it's often referred to in the literature as multi-partiality or omni-partiality. What does that mean? It means that I, as a mediator, say to the plaintiff, I'm here to help you get everything you need. At the same time, I say to defendant, I'm here to help you get everything you need. So then rather than saying I'm neutral, I'm not going to advocate for either, there is a more popular stance, I'd say, at least in commercial mediation in the US, where you do the opposite. And you say, I'm here to get you everything you need and you everything you need. But the advocates have to understand, and the parties as well, that you're doing that in both rooms. There is a more connected rapport building stance in leaning in to the needs of the parties rather than leaning away from them. Now, I understand that I am talking to a panel of judges as well as some prosecutors and probably others. So this may be a controversial stance. In court annex mediation, where the judges are, what I understand is the judges may be supervising a panel of mediators. Some of them may also be conciliating or mediating. That particular persona may have costs. And so please, I beg your forbearance, adjust this point to what you've already learned and what makes sense for you. But underneath this point, whether or not this is tenable or possible for you, understand that at least the data has shown that the parties request a more connected mediator. And there's many different ways that you can do that. So I'd say in summary, and I'll just project the Thomas Kilman one more second here so you can see this. In summary, this kind of stance of leaning into both sides is often seen as a more effective mediator persona. And then the trick is in how do you articulate that? And you might say, I'm here to help you get everything you need. And I'm also here to help them, as opposed to, I won't take a side for either. I'm moving on to point 3 and 4 here. And these skills are around reality testing. Reality testing is a skill that we use to ask people about the difficult aspects of their case, about risk and cost, essentially, or often about the legal issues. I want to demonstrate reality testing in what we call all 4 quadrants of Riskin's grid. So I'll introduce that and then show you reality testing in different quadrants. The skills that I think could be developed here, because this is what I see most mediators doing. New mediators, as soon as they see the error, the logical error, or the error because, either there's a statute they don't know about, or the costs don't make sense given the judicial system or the weight, something like that. As soon as they see the error, they say it. And that is a mediator no-no. Excuse me, just for one moment here. It's important. It's important for there to be a delay, often, between the moment you see the error and the moment you use the error. You take that, the logical error, and you put it in your back pocket because you're going to need it later when you close. And usually you don't have enough rapport yet to be able to utilize the skill set. So you take it, you put it in your back pocket, and you wait. When we train new mediators, and we've trained, we probably train, I don't know, close to 1,000 a year. many of them say, yeah, I'm not interested in being a mediator. I enjoyed taking the training, but it requires too much self-regulation. I really love being an advocate and I love just jumping in there. And as soon as I see it, saying it. And that is also a valid advocacy technique and one in negotiation that, often people excel from being able to jump into the fray and see what they say or say what they see immediately. But the mediator has to put it in their back pocket. Secondly, mediators often don't know how to ask the question and have that question that they ask also be a moment of maintaining or even building rapport. When we ask these questions about risk or cost, essentially asking someone like, why are you doing that? To do that in a way that builds the relationship instead of detracting from the relationship is particularly hard. Let me expose you to a little bit of something that may also be review. It's something called Riskin's Grid. And it's a way of thinking about the 4 different styles, and there are many more, of mediation. We have up here the evaluative or directive mediator versus the facilitative mediator. I see I'm not sharing screen. I thought I was. Apologies. The evaluative mediator down here, we have the facilitative mediator. So these 2 poles, evaluative directive, facilitative. Over here, we have something called narrow, which means you're asking questions of law, interpretation of rights. You're mediating in the shadow of the law. Over here, you're asking broad questions about interests, what I started the talk discussing, which is those needs and values. So here are 4 quadrants. Taking that into examples of questions, I want to give you an example of each of those quadrants. So you will see how the mediator might ask different types of questions. So we nickname these based on cities in the US. So I'm going to go back and show you that one more time. It's almost like I superimposed a map of the United States on top of this. So up here, the evaluative narrow mediator, we often nickname Seattle, Miami, down here, Boston, and Los Angeles. You can just ignore that on the slide. You would superimpose a beautiful country on top of that. And you could do the same. But as we're talking about evaluative narrow questions, I've chosen a case, and this is a case about disability. So in the United States, the American with Disabilities Act asks for, when an employee asks for accommodations, those accommodations must be reasonable. So the employer has to know about them, then the employer is required to give reasonable accommodations. I assume you have something similar, a schema that's similar. So the evaluative directive mediator would say something like, I'm concerned I'm not seeing the courts interpret reasonable accommodations in the way you're describing. You can see that's very directive. Does it build rapport? Maybe. Maybe, depending on who's in the room, depending on their learning style. You see, I would use this particular technique not based on my own personality, but based on what the parties in the room need. And many new mediators will make their interventions around reality testing based on their own personality, rather than the needs of the party and being party-centric. Here's another example. I'm going to give you an example from each quadrant, so we'll go through with that. The Los Angeles mediator, or the facilitative narrow mediator, so you see it's not directive, we're not telling you what to do, but we're more open, might be, do you know how courts interpret this term, reasonable accommodations? So you see the difference between, I'm not seeing the courts interpret reasonable accommodations in the way you're describing, and do you know how courts interpret reasonable accommodations? And there are rapport values in doing this Los Angeles style or the facilitative narrow with certain parties. You can see in a facilitative broad there, we're asking an open-ended question and we're asking it about interests. What will happen if you don't settle this here today? Tell me from your own language what you need in a workplace. Those are facilitative broad. Those questions build rapport more easily, and often you get just what you need in order to know how to settle. But most people, at least in my experience, don't ask as many of these types of questions. The direct abroad example, as you can see, is more of a wisdom persona. Someone saying, I'm sure this has had tremendous impact on your stress level and my guess your health. What would it be like to have this over with? Or if we're asking the questions around reasonable accommodations, what is it? Tell me more about how accessibility is important to you. Okay, so those are examples of Riskin's grid. So as you can see, the evaluative reality testing urges, recommends, but here, both of these are the same under narrow and broad. They urge and recommend, but here there's a difference between evaluating and counseling. I'm going to ask the questions so you can see the difference. Have you ever seen a jury ignore the videotape? It's a very narrow evaluative question. How would you defend firing without documentation? And you can see tone matters. How would you defend firing without documentation? Has a very different impact, likely, than, so how would you defend that firing without documentation? One might build rapport, one might detract. Now, that would be a question I would ask in caucus, just in case you're wondering if I would ask that in open session. I would never show to management that much deference. If I were in open session and they were both there, I would have to then adjust the question. And I would not do reality testing like that in open session. I would ask a reality testing question that applied to both of them. An example of the evaluate abroad is I've seen people in your situation, they're so relieved when it's all over. So a facilitative reality testing question. Are you aware of the last few jury verdicts? I'm not, so I'm curious. What's the judge likely to say about? Both of those questions are questions that might build rapport with the parties. And more broad questions, what's most important to you? What will it be like for you if you don't settle? So knowing how to leverage what we call the rapport bank account, how to make deposits in your rapport bank account, because when you settle, you will be making a withdrawal. Now, if you're mediating from a position of power, if you are mediating from the bench, you automatically likely have more rapport. The best mediators I know are the judges who are able to use something other than the positional power that they have. Because then when they get to impasse, they might be able to use the positional power. But if they've used up all their capital that way prior, they don't have that same leverage. So I see that particular mediator who also has positional power, which we absolutely know influences things, using this rapport bank account effectively as being some of the best mediators I've seen. Okay, we are going to, because of time, move past this particular scenario, though I'm certainly happy to share my slides and talk about our last three. The first is quite simply one that I have fear may not play in Brazil in the same way it plays in the United States. We'll have to find out. But new mediators fail to ask short, crisp questions. Let me give you an example. Well, now you've told me quite a bit about how the other party has liability, and you've given me quite a bit of evidence. You've shown me the documentation as well as revealed to me the potential witnesses that you will use. And you're making this argument for liability. However, when we get to damages, I'm trying to figure out where the damages are, because a court will not actually acknowledge liability in a significant way unless the damages are also significant. Okay. So help me understand what the damages are. You see that? Once again, I want to say that's not bad. It's long, it's clear, and it's instructive. But it's confusing to the parties. And I have seen the best mediators be able to ask those long questions occasionally, but then to juxtapose them with the crisp, clear, short question. Tell me about damages. And if I haven't said it before, tell me about, at least in the US, is a question. It's a question. And damages. Then the mediator keeps their mouth shut and allows the silence and the powerful, impactful questions to land. Now, I've given you an example about liability and damages, but where this technique of new mediators asking short, crisp questions is most effective is in decision-making questions. Helping people go from no to yes. And I say all the time, this is my job. My job description is essentially, I'm an expert in decision-making, because everybody comes into a mediation with a no. Most certainly they come in with a no. And I guide them on a process from no to yes. And I can pummel them. I can scare them. I can, there's a lot of things we can do. My experience is that I don't want to be scared or pummeled when I'm making a decision, personally. You are more apt to get me to go from no to yes if you ask me questions that require me to be thoughtful, reflective, think deeply about my own risk and the costs of conflict. That's me. I prefer those types of questions. And in many impasse, the types of decision-making questions that engender that type of reflection are impactful, short, crisp questions. Okay, the final skills we have here are new mediators fail to utilize the skill of empathy, and they also don't understand their value as not being part of the conflict. Let me check in. I'm gonna just check in very quickly here. I was gonna play a video, but we're not gonna do that. I'll refer you and give you the reference to the video at a later time. I'm checking on time. I just want to ask, it seems as if we're short on time, yes?
No, we are not short in time, Professor.
Okay, so I don't hear it when Judge Hoffman speaks, but I think he's telling me go a little long.
He's saying it's okay, right?
It's
no
okay,
matter the
okay.
time.
Okay, so not to worry about it so much. Okay, well then I will say a few words about empathy because I think it's so important. The first thing I will do rather than play this video is refer you to a video which you can get on YouTube or your equivalent. That is a Brene Brown video on empathy. It's about 4 minutes long, and I highly recommend that you watch that particular video. Here's the punchline of the video. If you have not seen it, basically, the video talks about empathy as the understanding that we are neurological containers, that I have neurons and you have the same neurons. And that what connects us is our acknowledgement of a human emotion in another person. And that empathy is not agreeing with someone But that empathy is in simply stating, I'm a human, you're a human. I see you're having a human experience of emotion. So it's not, I know your feelings. It's not, oh, I've been betrayed before. It's just, if you're seeing betrayal going on, oh, I see it. I see the betrayal. Betrayal so painful. That's a statement of empathy. And as Brene Brown talks about, it's a courageous statement because in order to see it in someone else, you probably have to have a little neurological feedback that's letting you know what that feels like. Empathy is the key, I would say, to resolving cases, especially in the United States, where the justice system and the court system, unlike civil law countries, it can last a long time, and people are completely worn down. I mean, every country is different. I know civil law systems, it can last a long time as well, but everybody's completely worn down and they feel as if the system itself has dehumanized them. So that simple statement of putting humanity back in often could be the impasse breaker, because they have likely not heard it from anyone in the system or their attorney for a while. So that statement of empathy is critical. I focus on teaching empathy to lawyers and to law students. And that's usually not something that is a preferred technique. Usually it's something that people prevent. Well, I'll say this, it's not part of legal culture. And so since it's not part of the culture, it can be discrediting to the advocates when they're using that language. It can be discrediting to the mediator in their own mind to be using that language, because we have been trained and paid to be able to be nimble in a different system. And I am one of them. The first time that I used an emotional word in a mediation, my heart was beating. It was a discrimination case. And someone was sent in a Christmas card that had disparaging remarks because they were not Christian. And it was in a workplace, and it turned into a equal employment case. And saying to the plaintiff or the petitioner a statement about their dignity being challenged, I remember my heart was beating. And that was probably 20 years ago. My heart would not beat at all right now. I could easily say such a thing, but it is a moment that is sometimes difficult. So I'm going to give you a format for that. It's what I call a stealth form of empathy. And this was introduced to me by a professor named Mark Goulston. He's written a book called Talking to Crazy, which is kind of a funny title of a book. It's a catchy title. He worked with suicidality for years. And so this particular technique of stealth empathy is a technique that was used in situations of suicidality. And I have adapted it and taught it to the clinicians in my clinic, and I found it incredibly effective for two reasons. One, there's a formula, and for those of us that are from disciplines that don't necessarily privilege emotional vocabulary, it's helpful to have a fill in the blank statement. So that's one reason. Number two, it normalizes emotion before it invites reflection. And that's particularly effective. And number three, I've never had it go wrong. When I've used this format, it always has worked or treated me well. It doesn't mean I've settled all of those cases, but I haven't had someone say, "What are you saying? That doesn't make any sense." I've always had the party open up more. So this is the stealth form of empathy. most people in your situation. So do you see the normalization effect of this? Most people in your situation. Then feel. Then you choose 3 or 4 words. The last word is always exhausted. Okay. And the concept behind that is that people are always, or people not always, I don't know, but people are tired when they're in conflict. They're tired when they're involved in litigation. And it's the safe emotional word. So the last one is always exhausted. Then you choose 2 or 3 other words. And those 2 or 3 other words might be words that you're seeing, words that you're guessing, or maybe even a word you're not seeing, but that you think most people would feel. Because sometimes there's a facade where you're seeing nothing, and yet you know if someone has lost their job, lost their house, lost their child, that there's a certain emotional narrative that goes with that as well. And so you might interject one of those words too. I do that with more caution. So most people in your situation, and then in your situation may be that generalized statement, or you can fill in the blank. But if you fill in the blank, you do it neutrally. Let me give you an example. If this were, and I'm just going to choose an example of recent, a lawsuit around a engagement ring. Even though the law seems to be clear in the US, we still have a number of lawsuits around engagement rings. Most people, now you could say who have been left at the altar, or you could say who are breaking up, or who are, but do you see both of those have different impacts? Most people left at the altar versus most people who are going through a breakup feel, right? So that's where you choose very carefully the in your situation. You fill in the rest of those words, and then you end with exhausted. Is it one of those? Most people in your situation feel betrayed, scared, anxious, or exhausted. Is it one of those? Usually my experience is this is the ultimate efficiency. You open it up, but that scoped language means that people then speak on it for a minute or two, and then it gets closed back up. Emotion is the ultimate efficiency. The final concept that I want to talk about is that most people misunderstand their value, which is being someone not in the conflict. And I'll just say a couple of words about that simply. Many new mediators try to overdo their job, which means they think they have to solve the problem. They work too hard, and they misunderstand the value of just being a listener. They forget to include silence. They forget to include a reflective presence. They forget to ask questions. They tell instead of ask. And there's something about, all I am here is a person of service. And this is how I think of my job is it's number one, service work as a mediator. If I'm helping people resolve conflicts, that is service work. It is not my conflict. And everyone knows that. And by virtue of my presence, I have added value. Okay. I fear I've gone on too long. I want to thank you in advance for your kind attention, and thank you for the kind invitation to come and speak to such an esteemed group. I will pause and let my conveners tell me what's next. Thank you so much.
Muito obrigado.
Well, good morning. First of all, I thank you and congratulate you for a talk. My question to you, Professor Blondell, is the following. Here in Brazil, a judge leading the mediation in a judicial hearing can be the same judge that will judge the case at the end. What is your opinion about this situation, about this peculiarity that we have to work as a mediator at the beginning, or during the case, and the same judge judge the case at the end?
it's a fascinating concept, and it is something that happens in the US as well. The typical pattern in the US is that the judge who mediates the case is not the same judge who then would be the bench officer. And there's a firewall between the two. Firewall meaning confidentiality. That is considered best practice. However, at lower courts, at many different types of courts, you see judges in informal settlement, essentially in status conferences, prior to going to the bench, doing the same thing. So even though the formal process of mediation, you wouldn't see that typically, you do see this happening. In the court annex mediation settings that I'm in, will often see a judge doing it from the bench, even, not even in chambers, as a more informal moment. I've traveled to Australia, where I worked with an administrative tribunal, and they had the same format, where the same judge that was assigned to be the bench officer or the fact finder also was the mediator. My comment on this, in terms of practice skills, first I'll give a philosophical comment, then I'll talk about practice skills. Philosophically, I cannot fault anyone ever trying to resolve a conflict. You know, I am in support of any human being on the planet trying to resolve a conflict prior. I do understand in our judicial system, some of the reason we have the best practice and the bifurcation of the roles. And in systems that have the resources to do that and the setup, there is some advantage to it, because then the bench officer is likely, and this is where I'm transitioning into talking about the practice skills. The bench officer is likely able to be more evaluative and directive if they are not the bench officer that's actually going to be hearing the case, in our system at least. So it allows that bench officer to flex their judicial muscles a bit, and have a more evaluative and directive approach. And honestly say, you know, there's a firewall between us. I don't know how this judge will decide this case. This is how I would decide this case. And we're a common law country, so there is an acceptance that there might be more variance in decision making, right? So having said that, I do think that typically, and I'd be very interested, this is such an interesting question to me, and I'm very much more interested in your answer than mine. But I do think that the bench officer is likely more effective as a facilitative mediator, because, well, part of it is I'm thinking they may fear appeal, even though that is a protected, that process of mediation is protected by confidentiality. If they let a little bit of their judicial decision-making known during that process by being more evaluative and directive, they might expose themselves to giving counsel a primer, a lesson on how to do a more effective appeal. So my guess is that it would be more effective to be more facilitative in contexts like that. But I'm very curious about your own comment, and you can choose now to share that with me, or maybe at some other later date I can find out more.
Thank you, Professor Blondell. And let me once again mention how happy I am that you could take part in this this module here organized by the court here in Paraná. I believe there are other questions, so I will open the floor to my colleagues, and later we can talk more about that, Professor. Thank you.
Thank you, Judge Barão. So can you hear me?
Yes,
We cannot hear
Professor
you,
Stephanie can hear me.
Fernando.
So
I can.
let me allow Judge Eliezer.
I can hear.
Can you make your
Quem está no canal português aqui não está ouvindo.
Can you make your question?
Who is in the Portuguese channel cannot hear Dr. Fernando.
Agora deu. Obrigado. Eu quero aproveitar para fazer gancho
Well, I would like to make a
pergunta,
connection
do Lorival.
to the previous question, to
o que eu
Dr.
gostaria
Lorival's
de
question,
trazer, tá?
and I would like to propose for
Foi
your
da
discussion
abordagem com
has to
relação,
do with the
que me pareceu
approach
muito interessante, a questão
that
do
was pretty interesting to
silêncio
me regarding the
do mediador,
silence
o momento
of the
em que,
mediator. I mean, that moment in which
utiliza
the
do
mediator
silêncio
relies
argumento,
on
né, da boa
silence
mediação.
to
Esse
perform a good
em que
mediation.
ele
This
faz
time, I mean, this delay
durante
between,
a discussão.
I mean, between this in the discussion
pergunta
being
longa,
made, and also the
quando o
long
mediador ele se
question when
alonga
mediator
demais nas suas colocações,
makes
e o ponto
too
que
long
me
of
pareceu
questions
muito
and
interessante
expositions. What
abordagem,
Professor
foi
Stephanie Blondell
justamente
said
esse,
was
de
very
que
interesting when
algo
she
que
said that
nós conversamos aqui nos cursos,
this is something that
mas
we discuss in our
tem aqui como
programs.
dos 7 itens que ela
And
coloca
it's
ali,
also
com
one of
muita
the 7
clareza,
items
do
she
ponto de
so
vista de
clearly
quando o mediador se
discusses.
estende
I
numa
mean,
pergunta muito
when
longa,
the mediator
aí ele fica,
makes
às
a
vezes,
long
dialogando consigo
question,
mesmo
dialoguing
durante
with himself or herself, as if
enfim,
he
durante a
was
sua
talking to
fala, durante a sua
himself
tentativa
during his during his
de conciliar
attempt
ali o
of
conflito
his attempt at conciliation
aproveitando o
and
gancho, a
resolution.
recomendação
So taking
que nós temos quando
this
se trata de uma mediação
advantage,
coletiva,
what is the recommendation
no
when
sentido
we
de
have
que
this
o
mediation,
juiz que
in the
participa da
sense that
mediação
the
desse
judge that
conflito
takes
coletivo,
part
que
in the
e
mediation of
essa
this
mediação
collective
sendo
dispute, and
infrutífera,
if this mediation is
o juiz deve
unsuccessful,
ele se abster de
should
julgar esse
the
processo,
judge
né?
um,
Se
remove
considerar
himself
ali,
from his case?
não se
Should
considerar isento o
he
suficiente e se afasta
say that he's
ali com os
not
nossos critérios ali de
fair
regime de
enough, and
suspeição
that he should
para
resign
atuar
from
no
the
processo?
case
A
and he should
recomendação que nós temos
remove
não
himself
é uma
from the
imposição legal,
or
mas
resign from
uma
the case? This is not a
recomendação
legal
em
imposition.
que
This is a
não atue
recommendation
por
that
questões da
the judge
confidencialidade,
doesn't
né?
preside
Nas
over
reuniões
that case
individuais,
due to
com cada
confidentiality
parte
issues.
litigante,
The
acaba tendo uma
questions with
informação que
each
depois pode
party
influenciar
may
sim
have
no seu
information that
critério de
later
julgamento.
can influence
Então, eu gostaria de trazer
in
essa
the judging
abordagem,
of the case. I would
juntamente
like to
aí
express,
com
to
a minha
present
questão.
this approach.
Espero ter sido claro
I hope I was clear. This is a
à
topic for
questão da tradução, se
discussion.
puder auxiliar, mas aí eu acho
If
que
I
o
can,
Fernando está nos ouvindo,
and
pode
Fernando is listening to
traduzir
us,
aí a
and
minha
also
fala.
maybe
Obrigado.
Fernando can add something to my question.
I'm happy to comment. I don't know if Fernando heard the invitation, but
Yes, I've heard, but you can comment. Please go ahead.
okay, I can comment. And then, so first of all, so two different things that I heard. And one is about the recusal of judges, the other about silence. So I'll just say in a few words about silence, and I'm glad you studied this, that, you know, really no one says anything negative after a silence, at least in the kind of US parlance. You wouldn't pause and then escalate. If you're pausing, you're likely to de-escalate. So if you see those pauses, you don't want to jump in as the mediator. You want to allow the silence because the reflection comes after the silence. And I have been in many a mediation where I could tell stories. Now I won't. But where that silence beget the resolution, led to the resolution. In terms of the recusal, there's in the way that the ethical rules are written in the US, they cover not only conflict of interest, the actual conflict of interest that might be created, and that's the principle that I would use here to apply to the scenario I think that you were setting out, and thank you so much for that question. It's not only actual conflict of interest, it's perceived conflict of interest. And both are important. Many of the ethical rules, not only for mediators, but other professions, also look at both this concept of actual conflict of interest as well as perceived. And actual would be, of course, if I had a case and it was Bank of America, and I was on the board of directors for Bank of America and receiving a fee for that particular role that I had, I would have an actual conflict of interest. The perceived conflict of interest when you're talking about court annex mediation is tricky, right? Because the perception is such that anyone could see that as a conflict of interest. So they have to understand the system and that you are utilizing your resources of the bench from this place in order to, serve the overall system, the institution. Most of us, I'm going to say this, in my career, there have been very few cases I felt like I'm just not neutral. I mean, in neutrality or impartiality or multi-partiality, whatever it is, it's a muscle. It's a muscle we develop. And I do feel like in most cases, I'm able to separate my distaste for a particular perspective and my ability to serve neutrally. Like, I don't have to feel neutrally. I just have to behave neutrally, right? They are two different things. And if I had to feel neutrally, well, then I wouldn't be equipped for any case. We get to have our own inner world as mediators. And we get to have preferences as well. That's not what neutrality or impartiality is. So there are very few cases I would recuse myself from based on my own ability to serve. However, there are some cases where I see that the party's perception is such that the barrier is too much to overcome. And in cases like that, I might recuse myself. And recuse is a word that, I guess I would say for me, since I'm not a bench officer, withdraw from the case. I hope that was responsive to the question. I'm not sure that it was, but you'll let me know.
Okay, I'm seeing that you have answered.
Foi precisa.
That was
Exatamente.
right there. Very precise.
Well, first I will say, so I've run two different employment mediation programs, one for a city government and one for a county that was a tri-county area. So I have a strong opinion about this. And it may be somewhat cultural. There is something in the US where for lack of better word, intimacy of one-on-one negotiation is where deals get done. When you have a ton of people in the room, deals tend not to get done. So that need for caucus is strong in employment mediation, so that people have that intimacy to say what they need to say. And this is true in the labor world as well, where I ran both a labor management as well as employment. Labor we would use to refer to the collective bargaining agreement in unionized environments, employment discrimination cases. That's the distinction we make. So the caucus is critical to be able to be effective. However, that in many of these cases, they may be terminating the employment relationship, or they may be continuing the employment relationship. And in those cases where tomorrow the mediator leaves and the employer and employee are right back in their scenario, it's critical to also have open session. Some of that is almost ritualized. It's almost staged. It's almost theater. You might even plan how you're going to do it in caucus, but it's an important moment to normalize the fact that there had been either litigation or some other strife. And how are we going to behave? What will be the rules of engagement when we engage back in to the relationship post-settlement? So that they both exist is very important, I think, in my context in employment. Now, the specific question that you asked was about how long or the transition. I think every case that's different for me. I do. I think that, certainly we always end in a caucus, but there's a myth, I think it's a myth in mediation, that there needs to be symmetry. As long as the parties understand why you're going back and forth between the two processes, there does not, in my opinion, need to be symmetry. It can be quite haphazard, in fact. So that is something that I think is very much dependent on the case, but the premise and the underlying assumption is that both would happen.
Okay, thank you. And we have one chance.
Thank you, Judge, for your question. And at this point, my experience is as a scholar and not as a practitioner. So I will be learning that. I will say that we are in the thick of it as professors. And so many of our professors have actually said, okay, use AI to write the best paper possible, and that they have eliminated the tension by doing that. Many mediators I know are currently using the skill set in their mediations, their Zoom mediations, and to assist the administration of their practice. We certainly have seen it used in large-scale systems where there are repeated disputes, like that of eBay or Amazon or something like that. My own particular experience is limited, so I've been studying and fascinated at the potential. I said I'm an older in life mom, and I have a 6-year-old, and I often said, I don't know if my daughter's going to learn how to drive a car. And she will definitely learn how to drive a car in the United States. Our legislative system is not going to allow self-driven cars to be pervasive within the next 10 years. That's not going to happen. However, will she ever learn to write a paper? I don't know.
Okay, thank you. Thank you so much. So let me check with the judges if they want to have the final greetings.
Bom, minha parte, eu agradeço.
Well, I would
Posso
like
dizer
to
que não
thank you.
é
I
nenhuma
can tell you
surpresa
that it's
o
no
aprendizado
surprise
que
at
tivemos
all
agora, porque
how
sabia já de
important these
antemão
lessons that you gave
que
us were,
iríamos
because I knew
ouvir a professora e
beforehand
não tinha como
we would
não
listen to
ouvi-la e não
you and
aprender
would
alguma
be
coisa.
a great
Mas
moment
confesso
of
que
learning, a great source of
efetivamente
learning. And so
a
let me
forma,
tell you
a
that
abordagem
effectively
que
the
trouxe
way and the
efetivamente
approach that you brought
sempre
to
contribui
us
e muito e
always
espero,
helps us, always
Fernando,
contributes so
poder
much
ouvir
to our
novamente a
program.
doutora
And
Stephanie em
Dr.
outras
Fernando, I hope
oportunidades
we
e
can
podemos
listen to
aprofundar
Professor
aqui esses
Blondell in
conceitos
other
que
opportunities
ela
so we can
constrói tão
deepen these
bem e que
concepts.
sua
She's so
figura
well
é
put, and
simpática,
she's such
agradável,
a friendly,
acolhedora,
nice person,
nos
so
brindou aqui
caring.
com essa
And
magnífica exposição.
thank you
Muito
for
obrigado.
this wonderful presentation. Thank
Também
you very
quero
much.
agradecer novamente a
I
professora
would like
Stephanie
to
pela
thank
palestra, pelos
Professor
conhecimentos
Stephanie
transmitidos
Blondell for
com
her talk, for
clareza e com
the
simpatia.
concepts she conveyed to us
Ficamos
so
muito
clearly,
felizes
so
e certamente sairemos
so
daqui com
interestingly,
uma carga
and
maior de
we'll certainly
conhecimento com
leave
essa palestra.
this
Muito
meeting
obrigado.
with lessons learned. Thank you very
Parabenizo
much.
também, professora.
I would
Que
like to
renova a alegria de
congratulate
tê-la
you,
aqui
Professor
no,
Blondell.
no
We
Tribunal
are
do
happy
Trabalho do
to
Paraná.
welcome
Muito
you here
obrigado.
at the Paraná Regional Labor